Hey everybody, this is Tracy and I am back with the correct information that I said I was going to bring to you guys in my last video. I do apologize for the confusion. Just so much stuff is being filed back to back that I'm having trouble getting caught up. Like if I don't read these motions to you as soon as they come out and as soon as I get them, then I start getting them confused with other documents. So I do apologize for that. So let's backtrack to last week. Thomas Farinella filed a motion and it says, Dear Judge Donnelly, on August 3rd, 2021, the court partially ruled on the government's motion in limine to admit certain uncharged acts. The reserved ruling on the uncharged acts as to Jane Doe number 7, Jane Doe number 9, Jane Doe number 11, Jane Doe number 12, Jane Doe number 14, Jane Doe number 15. It should be noted they were only recently disclosed by the government. Counsel for Mr. Kelly respectfully submits the following opposition to the remaining uncharged acts in the government's motion of limine. Uncharged acts as to Jane Doe 11 and 12 should be excluded. When a person settles a civil case, there should not be an adverse inference drawn from the settlement. There are many reasons why parties settle civil cases, even if they are perceived as frivolous. There is a practical value in reaching a settlement, and that is there is a guaranteed outcome and the matter is resolved. To make references to these settlements only for the purpose of trying to prove that Mr. Kelly is guilty undermines Federal Rules of Evidence 403, and this use of settlement should not be permitted. Additionally, Jane Doe number 12 is deceased, and any evidence that cannot be authenticated by her should be excluded. In the alternative, the court should exclude a jury instruction regards to settlement in civil cases. So let's see what the government had to say about that. So they say the government seeks to offer evidence that the defendant... No, I don't know. Hold on a second. Okay, uncharged acts as to Jane Doe number 7, Jane Doe number 9, 11, 12, 14, and 15, and employee number 1 should be excluded. The evidence of the remaining uncharged acts the government seeks to introduce as evidence should be precluded. The Court of Appeals has repeatedly upheld rulings by district courts on the admissibility of uncharged crime evidence, but its decisions do not dictate what district courts must or even should do in a particular case. Instead, they hold that a particular ruling either was or was not an abuse of discretion. United States versus Williams, which was heard by the Second Circuit in 2009, standard for reviewing evidentiary ruling. This court is a gatekeeper. It retains a wide latitude to exclude irrelevant, repetitive, or cumulative evidence. United States versus Holmes, Second Circuit in 1995, as well as evidence that is unduly prejudicial under Rules 403's balancing standard. Under that standard, even relevant evidence may be precluded. The Supreme Court has reprised advisory committee notes on Rules 403 and 403 and 404B, which make clear that the probative value of an item of proof is informed by the availability of evidentiary alternatives. Old Chief versus United States from 1997. The more abundant the existence of other proof on the same point, the less probative value the challenge proof has. And then United States versus Asaro, which was in the Eastern District of New York in 2015. Other evidence: the government had to establish a close relationship between defendant and certain associates rendered the other crime's evidence unnecessary for the purpose. Thus, the probative value is minimal. The government has asserted variously that the uncharged crime evidence shows the existence, purpose, and means and methods of the charged enterprise, the relationship of trust between the members, and that it is necessary background or inextricably intertwined with the charged offenses. The standard is difficult to counter, however, based on the government's case. The government has a plethora of other evidence to use and present to the jury. Indeed, the government never contends that the uncharged cases are necessary to fill any gaps in its case or shore up and perceived weakness. Therefore, the only purpose for this evidence is to further pile on, using the excessive amounts of unnecessary evidence to sway the jury as to Mr. Kelly's guilt solely based on the sheer volume of such evidence. Additionally, this evidence is cumulative and unnecessary to the government's case. Under such circumstances, the court should not permit evidence of uncharged offenses that will suggest the defendant's propensity to commit serious crimes and serve to alleviate jurors' doubts as to his guilt of the charged offenses. The government does not and cannot argue that the prior arose out of the same transaction or series of transactions as the charged offense, or was inextricably intertwined with the evidence regarding the charged offense, or is necessary to complete the story of the crime on trial. The government has done nothing more than stitch together a series of events spanning over 3 decades in an attempt to create an irrefutable mirage of guilt as to Mr. Kelly, which will make it impossible for him to receive a fair trial. The only purpose for this evidence is to show guilt, which is severely prejudicial. The alleged events the government has stringed together to establish this bogus enterprise. Okay, Thomas, we see you here. He say they established this bogus enterprise are independent events, and there is nothing unique or distinct about these independent personal relationships. It is a certainty that if the government is permitted to produce those uncharged acts, it will confuse the jury and Mr. Kelly will be deprived of his right to a fair trial. I agree with you. For the foregoing reasons, Mr. Kelly respectfully asks the court to limit the government's presentation of uncharged acts evidence by not permitting the remaining uncharged acts to be used at trial by the government. At the least, a hearing should be held before any of the remaining uncharged acts are ruled admissible, where the government will be required to articulate a specific theory of relevance for each uncharged act it seeks to introduce. Defense counsel would then be able to urge exclusion on Rule 403 grounds. And this was from Thomas Farinella, New York, New York. Okay, now we're going to go to the response from the prosecution to this particular motion. I was confused in that last video. And once again, I do apologize. So, dear Judge Dunley, the government writes in reply to the defendant's supplemental opposition to the government's motion to admit other acts evidence. See letter of Thomas A. Farinella to the court dated August 6th. Blah, 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 blah. For the reasons set forth herein, and it is and its initial memorandum, the government submits that the court should uphold its initial rulings and permit the government to introduce evidence related to Jane Doe 7, 9, 11, 12, and 14, and 15. Okay, let's see. They have a note on the bottom of page 1 that says the defendant asserts that this conduct was only recently disclosed by the government. And then she says the defendant is correct with respect to Jane Doe number 7 and Jane Doe 11 and 12, but not as to Jane Doe 9, 14, and 15. The allegations as to which were disclosed in its production of 3500 material on February 5th, 2021. Notably, the Section 3500 material for the more recent disclosed witnesses is not voluminous and has been produced to the defendant well in advance of trial. And then they cite 18 United States Code Section 3500 requiring disclosure of Section 3500 material to the defendant. Okay, so 1, the evidence relating to Jane Doe 11 and 12 should be admitted. The government seeks to offer evidence that the defendant exposed Jane Doe number 11 to herpes by engaging in unprotected sex, and Jane Doe number 11 after she asked him whether he had any STDs, that she thereafter contracted herpes, and that she communicated to the defendant that she believed she contracted it from him. Such evidence is relevant to showing that the defendant in fact had herpes as early as 2003, and therefore to support Jane Doe number 4's account that she contracted herpes from him in or about 2009, and Jane Doe number 5 and Jane Doe number 6's account that the defendant exposed both of them to herpes in 2015 and 2017 through 18, respectively. Jane Doe number 11's account that she specifically asked the defendant whether he was okay prior to having unprotected sex with the defendant, referring to whether he had any STDs, also corroborates numerous victims' accounts that it was the defendant's practice to not use protection when engaging in intercourse and to disregard any risk of transmitting STDs. Finally, Jane Doe number 11's testimony that she confronted the defendant about both her herpes diagnosis and her belief that she contracted it from him is relevant to show that the defendant was on notice that herpes is an STD and that the defendant had herpes, which is directly relevant to his knowledge and intent for the charged crimes related to his exposing charged victims to herpes. So what is the proof that they have? Did she record the conversation? This is hearsay. How do you know that this conversation actually took place? Were they texting each other? I need to know, what is the proof? Was there somebody standing there listening to the conversation? Okay, then it goes on to say the government also seeks to admit evidence of the defendant's entry into settlement agreements with Jane Doe 11 and 12, while Rule 408 of the Federal Rules of Evidence prohibits the use of compromise, offers, and negotiations to prove a disputed claim. The government seeks to offer the evidence for several permissible reasons. See Federal Rules of Evidence 408B. The court may admit this evidence for another purpose, such as proving a witness's bias or prejudice, negating a contention of undue delay, or proving an effort to obstruct a criminal investigation or prosecution. First, evidence as to the existence of the settlement agreement explains why Jane Doe number 11 did not previously disclose to anyone, including law enforcement, the defendant's exposure of herpes to her. In addition, the agreements themselves would strongly corroborate Jane Doe number 11's account. Finally, and significantly, the defendant's payments of hundreds of thousands of dollars as part of settlement agreements were among the means and methods used by the enterprise to perpetrate and protect the enterprise. Child, please, whatever. The defendant, with the help of other members of the enterprise, paid significant sums of money to discourage the defendant's victims from disclosing to anyone, including law enforcement, the defendant's criminal conduct. Now, in order for them to say that the enterprise encouraged this, wouldn't they have to have somebody in that indictment who was on his legal team, who was with the recording agency, like whoever was orchestrating these settlements? Shouldn't that person be in the indictment as well? And if they're saying that it was Darryl McDavid, that is the Northern District of Illinois. Y'all didn't charge him in the Eastern District of New York. So how are you talking about that was part of this one-man enterprise y'all got going on? Anyway, number 2. The court suggested that the defendant could stipulate, I'm sorry, this is a note, another note that they've written at the bottom of the paperwork. The court suggested that the defendant could stipulate that he knew that he had herpes and that it was a sexually transmitted disease, and that such evidence may then not be necessary. Even if he were to stipulate a stipulation he has not yet offered to make, the government should be permitted to introduce evidence relating to Jane Doe number 11. See United States versus Salami, which was in the Second Circuit, 1988. A criminal defendant may not stipulate or admit his way out of the full evidentiary force of the case as the government chooses to present it, quoting Old Chief versus United States, which was a case from 1997. So I guess they're saying that they told R. Kelly if he just admit he had herpes, that they wouldn't bring in these extra people. Oh, Lord have mercy. This is just too much. So number 2, evidence relating to Jane Doe number 7, 9, 14, and 15 should be admitted for the reasons described in the government's initial memorandum and consistent with the court's prior rulings. The government respectfully submits that evidence related to Jane Doe number 7, 9, and 14, and 15 should be admitted and will not reiterate each of those arguments herein. In his opposition, the defendant cites only the general principles of evidence, all of which the court was well aware of when it initially allowed the government to introduce evidence related to number 7, 9, 14, and 15. There is thus no reason to disturb any of those rulings. And then there was a long ass note at the bottom of that page. And that note says the government does not currently have a copy of the settlement agreement between the defendant and Jane Doe number 11, but other agreements in the government's possession show that they prohibit virtually any disclosure, including voluntary disclosure to law enforcement, even if the agreement in the government's possession would arguably allow disclosure to law enforcement following a court-ordered subpoena. The agreements are written in a manner that they purport to prohibit even that disclosure, though relevant precedent makes clear that such a prohibition would be against public policy and therefore unenforceable. See Quino versus Allah, which was in the Eastern District of New York in 2018. Courts throughout the country have found that the public policy interests at stake, the reporting of possible crimes to the authorities, is one of the highest orders and is indisputably well defined and dominant in the jurisprudence of contract law. Internal quotation marks omitted. See also Brandsburg versus Hayes, which was from 1972, stating that it is obvious that agreements to conceal information relevant to commission of crime have very little to recommend them from the standpoint of public policy, and concluding that it is apparent that concealment of crime and agreements to do so are not looked upon with favor. Leichman versus Sperry Sun Well Surveying Company, which was heard in the 10th Circuit, 1972. It is public policy in Oklahoma and everywhere to encourage the disclosure of criminal activity. Cosby versus American Media Incorporated. This was Pennsylvania 2016. Settlement agreement unenforceable as being against public policy to the extent that it purports to prevent its signatories, alleged victims of assault, from voluntarily disclosing information about crimes to law enforcement authorities. Well, did we just see that get overruled in the courts, y'all? So I don't know why they threw that in there. But anyway, they're saying that the commission of a crime. What was the commission of the crime? Okay, because I thought these they were talking about the herpes, that he was sued for giving people herpes. But if it happened in Chicago, do Chicago have laws about giving people herpes? I'm confused about the government's response here. But anyway, that was Thomas Faranella's motion from last week. This was the government's response, which came in today. And basically, the judge has already allowed these people to testify. Now, whether she will overturn her decision is probably unlikely, but we will wait to see how this plays out. And then the motion that he filed earlier today, they are still waiting on Judge Donnelly to rule. And so as soon as that ruling comes down, I will let you guys know. And once again, I apologize for the confusion between these two videos. So that's it for me. Go ahead, leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.